Welcome back to PHCodal channel. Today, we're diving into a massive, absolutely bedrock topic for your criminal procedure recitations, the rights of the accused. We're going to break down the constitutional shield that protects individuals and then look at the strategic, statutory immunities the state uses to uncover the truth when that shield goes up. If you're a 1L student trying to map out exactly how these concepts interact for your upcoming exams, you are in the exact right place.
Here's our roadmap for this explainer. We'll start with the core constitutional shield, move into the right to silence, explore the immunity exchange, and finally wrap up with legislative immunity. Let's get right into it.
Part 1. The core constitutional shield.
So, Article 3, Section 14, Paragraph 2 of the 1987 Constitution is literally your baseline. It states, "In all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved." This guarantee of due process and the presumption of innocence is the absolute foundation of criminal law. You really have to internalize that the state enters the courtroom with a massive burden. The accused doesn't have to lift a finger to prove their innocence. The state has to prove their guilt beyond a reasonable doubt. This provision also locks in the right to be heard, the right to a speedy, impartial, and public trial, and the right to meet witnesses face to face.
Now, how does that constitutional mandate actually translate into everyday court procedure? Well, under Rule 115 of the Rules of Court, this expands into 9 specific rights you absolutely need to nail down. You've got the presumption of innocence, the right to be informed of the accusation, the right to be present and defended by counsel, the right to testify, the exemption from self-incrimination, the right to confront witnesses, the right to compulsory process, which basically means forcing witnesses to show up for your defense, the right to a speedy trial, and the right to appeal. Memorize this list. It's the armor the law provides to every single accused person.
But here's a curveball professors love to throw at you: trial in absentia. While the accused has a fundamental right to be present at their trial, the Constitution does allow the proceedings to continue without them, but it is definitely not automatic. You have to check 3 strict boxes. First, the accused must have already been arraigned. Second, they must have been duly notified of the trial date. And third, their failure to appear has to be completely unjustifiable. If all 3 conditions are met, the trial just rolls on without them.
Moving on to Part 2. The right to silence.
Let's zero in on a specific, right under Rule 1115, that creates a really fascinating tension. Article 3, Section 17 of the Constitution drops this incredibly powerful line: "No person shall be compelled to be a witness against himself." This is the right against self-incrimination. It essentially ensures the state cannot force you to be the architect of your own destruction. But think about this practically for a second. This right is a massive headache for prosecutors, especially when they're trying to get insiders to confess or testify against co-conspirators in really complex crimes.
And this sets up what we call the prosecutor's dilemma. Picture this. How do you prove a secretive conspiracy, like widespread corruption, a drug syndicate, or organized crime, when the literally only people who know what happened all have an absolute constitutional right to remain completely silent? You can't torture them, and you can't force them to take the stand. So how on earth does the state get the evidence it desperately needs?
Which brings us perfectly to Part 3, the immunity exchange.
To pierce that veil of silence, the state basically offers a deal. On one side, you have the constitutional right against self-incrimination, where a witness can just invoke their right to silence and shut down. On the other side, the state introduces statutory immunity. The state essentially says, hey, if you tell us everything and testify against the big fish, we guarantee your testimony won't be used to prosecute you. By removing the threat of prosecution, the state cleverly removes the foundation of the right against self-incrimination. The witness is now compelled to testify, but in exchange, they're completely shielded.
As a 1L, you've got to know exactly who can hand out these deals. For instance, under Section 17 of the Ombudsman Act of 1989, the Ombudsman can grant immunity in graft and corruption cases. Under Section 5 of Executive Order 14, the PCGG can grant immunity to help recover ill-gotten wealth. Even the Constitution itself gets in on this. Article 13, Section 18, Paragraph 8 gives the Commission on Human Rights the power to grant immunity to uncover the truth about human rights violations.
A really specific and cool example of this in action is Presidential Decree 74-9. This decree protects bribe givers who voluntarily come forward to testify against corrupt public officials. Now, why do this? Because bribery happens in the shadows, right? The giver and the receiver are both guilty. If the giver knows they'll go straight to jail for confessing, they are never going to talk. PD 749 recognizes that exposing corruption requires insider cooperation, so it strategically grants the giver immunity to catch the bigger fish, the corrupt official.
Another massive tool for prosecutors is Republic Act 6981, the Witness Protection Program. When an insider is admitted as a state witness here, they give up their right to silence entirely. Section 14 makes it crystal clear. They are compelled to testify and cannot use the self-incrimination defense. But in exchange, they gain total legal immunity from criminal prosecution for that offense. Plus, they get physical protection, secure housing, and even livelihood assistance. It's the ultimate legal trade-off.
Finally, Part 4, Legislative Immunity. Let's pivot slightly, because Article 6, Section 11 of the Constitution grants a completely different type of protection based purely on status. It states that senators and members of the House of Representatives are privileged from arrest while Congress is in session for offenses punishable by not more than 6 years of imprisonment. This isn't about trading testimony for freedom like the Witness Protection Program. This is parliamentary immunity. It's designed to protect the legislative process itself, making sure lawmakers can't be harassed with petty arrests that would stop them from attending sessions and doing the people's work. If there's one thing you remember for your recitations here, make it the number 6. That is the magic number. This immunity from arrest only applies to offenses punishable by not more than 6 years. If a lawmaker commits murder, which obviously carries a much heavier penalty, this privilege absolutely does not apply. And it exclusively applies while Congress is actually in session. If they're on recess, they can be arrested just like anyone else. All right, let's tie this whole thing together. You now have the framework for your exams. You have the bedrock constitutional shield of Rule 115, the presumption of innocence, due process, and the right to silence. These exist to protect the individual from the overwhelming power of the state. But you also know these strategic statutory workarounds, like the WPP, the Ombudsman's powers, and PD 749, that the state uses to ethically bypass that silence, trade immunity for evidence, and gather the truth. And hey, while we're talking about immunity, as a law student, don't forget the ultimate boss-level protection outlined in Section 3, Article 16, state immunity from suit. While the state grants immunity to individuals to gather evidence, the state itself cannot be sued without its consent, maintaining its very own ultimate protective shield.
But here is a thought to chew on before your next class. What happens if a state witness under RA 6981 makes the deal, gets the immunity, but then just refuses to testify or outright lies on the stand? Well, under Section 13 of the law, violating this immunity contract leads to immediate consequences. You face contempt of court, your immunity is instantly stripped away, and you face criminal prosecution for the very crime you were trying to escape in the first place, plus perjury. The state definitely does not play games with immunity. I hope this breakdown gives you a rock-solid structural understanding of the rights of the accused and the mechanisms of state immunity. Thank you so much for watching. Please like, comment, and subscribe. See you in the next explainer.